Hey all, welcome back to the Law Read Slowly. So in the last session, we were discussing about the introduction to written statement. I had told you at what stage written statement comes into the picture. In fact, that should be amply clear to you by now because we have discussed the trajectory of a suit so many times and we have recounted and revised it so many times in the sessions itself that you should be very crystal clear as to where does a written statement fall in that whole trajectory. So I told you written statement is the reply of the defendant, that is the opposite party of the plaintiff. Plaintiff is the one who has come to the court with his side of the story by his plaint. We've seen at length what's a plaint, how it's written. Now, defendant should get a chance, audio alterum partem. Everybody has a right to be heard before they're condemned. The defendant will have a chance given by the law to be heard on his side of the story with respect to whatever the plaintiff has raised in the court. What will defendant do in his reply? Will he say that, oh, I agree to everything that the plaintiff has said, so please settle issues against me, hold me liable? No. I mean, unless you are a very strong believer of justice, and if you were one, you wouldn't even have done the wrong in the first place, not leading astray. So, defendant will here deny everything that is there in the plaint, which is leading to a liability against him. So, if the plaint says defendant breached the contract, defendant will say, I did not breach the contract. If the plaint says there was a valid contract between me and the defendant, which the defendant has failed to perform, defendant can either say there wasn't even a contract between us. I wasn't even in this country when the plaintiff is saying he entered into a contract with me. Or defendant can say, okay, there was a contract, but it was vitiated by fraud, by coercion, by misrepresentation, by undue influence. Your Contract Act 1872 gives you all of these things which make a contract to not be a valid one. Hence, what is it? It's a void agreement, voidable agreement. So defendant can say that also. What else defendant can say? Defendant can say there was no contract only because, very interesting, he can say that plaintiff is saying he entered into a contract with C. Imagine this fact situation. Plaintiff is saying I entered into a contract with C, who is the agent of defendant B. So the contract between A and C is the agent of B. So anything C does as per the law of agency under the Contract Act, anything your agent does will bind you, the principal. So since principal of C is the defendant, so when I entered into a contract with C, he was entering it on behalf of the defendant B. So now A is suing B for the performance of that contract. If I am the shopkeeper, I send my employee to go to a customer and enter into a contract with him on my behalf to sell something. Then whatever contract the employee is making on my behalf with that customer, I will only perform, right? Employee will not bring stuff from his house to fulfill that contract. If he's entering into that contract on my behalf, so I will have to perform it. Why will I have to perform it? Because that employee, that agent is my agent. I have employed that agent. I have given him the power to go do things, go enter into contract on my behalf. That is why I'll be bound. That is why A is saying, for example, in this fact situation, A is saying that C was the agent of B, and I entered into a contract with C, who was entering it on behalf of B. So now B can be bound by that contract, and I'm suing B to perform that contract. In his written statement, B can say that fine, A entered into a contract with C, and yes, this was the contract. Whatever he's saying, I can't say okay he did, but what if contract has been attached? Then okay, A entered into a contract with C, fine, but C was never my agent. I have never appointed C as my agent, either orally or by written power of attorney or by a contract of agency of any other sort. I never appointed C to be my agent. So if C is not my agent, then there is no valid contract between A and me. There may be, I don't care. Why will the defendant care? Why would the defendant want to make claims that he can't justify? He will say, I don't know what contract A and C have, but what I can say is C was not my agent when A entered into a contract with him. So whatever C was doing, I am not bound by it. So A has no case against me because that contract was not made with my agent. It was made with any random person C, who A is saying was my agent, but I am telling you he was not my agent. Of course, defendant will give his evidence to prove this, and plaintiff will also give his evidence to prove at the evidence stage. You know, evidence stage is different. We have discussed in the trajectory. At that stage, both parties will give their evidence to prove their sides, but defendant can say that this C was not even my agent. So even if A entered into a contract with C, how am I bound by it? See, different kinds of defenses, different kinds of pleadings the defendant can raise in his written statement. What are the examples did we take? We took an example of section 26 of SRA. I didn't mention the section last time. I'll make you read it also with me. So defendant will say, fine, there was a contract between me and the plaintiff, but there was a mistake in that contract. I have an email which he will present at the evidence stage. I'm telling you for the sake of fuller story for you to picture it in your mind. The defendant is there was an email between A and B. A is plaintiff, B is defendant. In which email they have written that yes, okay, A says I want to buy your land B. B says okay, I will take 25 lakh rupees for it. A says yes, okay, agreed. They've agreed in that email. So that email is the evidence of the intention of A and B. What was the intention of A and B to enter into a contract? The contract was supposed to be that B will sell his land to A for 25 lakh rupees to be paid by A. And then they have agreed in that email only that okay, let's do a written contract, let's get it registered, because Transfer of Property Act 1882 requires that your sale deeds have to be registered. So they get it registered, they put it in writing and everything. Now that written contract that they have made there, because the typist made an error, that instead of writing 25 lakhs, he has omitted 1 0 and it says 2,50,000 rupees. Plaintiff is very happy with this error, and now he's saying that no, it wasn't an error. So I mean, he would not say it wasn't an error, because why would you in your plaint say that okay, there is something wrong with my pleading? In his plaint, he will confidently say there was a contract between us. In that contract, defendant had agreed to sell me his land for 2,50,000 rupees, and I have been ready, and I have even tendered 2,50,000 rupees to the defendant to perform the contract, and he is not performing it. That's all the plaintiff will say. Now, defendant will tell it in his written statement, the full set of pleadings, the full story from his side, that no, the contract was never supposed to be for 2,50,000 rupees. It was supposed to be for 25 lakh rupees. Because we agreed over an email, and plaintiff brought the contracts over and they were printed and everything. I thought, of course, we have intended to enter into a contract for 25 lakh rupees. So, of course, the contract is going to say 25 lakh rupees. And I didn't know that it says 2,50,000 rupees. So when I signed it, my intention was to perform a contract for 25 lakh rupees. And now the plaintiff is taking benefit of this mistake and forcing 2,50,000 rupees on me. So while plaintiff is saying that I was giving him money as per the contract to perform the contract, defendant will say he was not giving you money as per the contract, because money as per the contract was 25 lakh rupees. This was a clerical error. This was a typographical error only. Plaintiff was giving me 2,50,000. That's fine. I also agree as a defendant that yes, on this date plaintiff tendered 2,50,000 rupees to me. But I don't agree to the fact that 2,50,000 rupees was the sale consideration. It wasn't sale consideration. Sale consideration was 25 lakh rupees, which plaintiff never tendered. So plaintiff cannot say that he was ready and willing to perform the contract. He was ready and willing to give me 2,50,000 rupees only, which is not the contract. The real intention of the contract was to sell the land for 25 lakh rupees. Now, this is a very human problem that can happen in real life also. So, this is being dealt with in the Specific Relief Act. So, this Specific Relief Act, the job of Specific Relief Act is to give you different remedies for different issues. And one of the remedies that it gives you is rectification. What do you rectify? You rectify something that has a mistake, like a contract. And it envisages this exact situation, that where there's a contract and there's a mistake in that contract, and the plaintiff has filed a case for specific performance of that contract, and the defendant comes to court and argues that there was a mistake in that contract, that is why I have not transferred my land or performed that contract. Then defendant can come to the court as per Specific Relief Act and seek the relief of rectification in the same case that the plaintiff has filed. It will not be that now, okay, defendant, if you want the correction to be done, go file a new case. Why? You don't want multiplicity of cases. You want to reduce litigation. So, Specific Relief Act says that in the same case which the plaintiff has filed against the defendant to get specific performance of the contract, in the same case, defendant can argue that there's a mistake in the contract, and of course, he will give evidence of what? That emails, to show that yes, there was actually a mistake and the real intention was something different. and defendant can seek the relief of getting that rectification done. I'll read out section 26 for you. So it will become one of the prayers of the defendant. Section 26. Section 26. So here, see, if you see, it's chapter 3, rectification of instruments. Instruments is a umbrella term for all kinds of documents that create rights for people, like contracts, stuff like that. So they're all instruments. Checks are also instruments. Negotiable Instruments Act, forget it. Instruments. Section 26. When instrument may be rectified, when can you ask for rectification? When through fraud or a mutual mistake of the parties. So either fraudulently plaintiff gave some money to the typist, that you omit 10, or both of them were actually wanting to do 25 lakh contract, typist made some mistake. When through fraud or a mutual mistake of the parties, a contract, I'm omitting all that, that's not relevant for us. So after a contract, directly come here. A contract does not express their real intention. Of whose real intention? Both the parties. Their real intention is what? 25 lakhs. So this contract of 2,50,000 is not representing the correct intention. Does not express their real intention, then what can they do? First, either party or his representative in interest may institute a suit to have the instrument rectified. So if the defendant already knew that there was a mistake, he could have himself filed a case in the court to get that mistake corrected and get the relief of rectification from the court. But since, okay, let's say in our case, because we're already dealing with the plaintiff's case, right, who has already filed a case for specific performance and he's saying defendant has breached. So we can't now say that defendant should do this. So forget that. So suppose in our facts, defendant was unaware, he was thinking, fine, this contract is 25 lakhs and he signed it and everything, and he only got to know that the contract contains a mistake with respect to the amount. When did he get to know this? When plaintiff showed up at his doorstep with 2,50,000 rupees and put the contract in his face and said, see, it says 2,50,000. Now take this money and give me your land. That is when defendant discovered that there's a mistake. And so defendant must have said, okay, please correct this contract. And plaintiff was like, okay, I'm not correcting it. And defendant, and in the meantime, plaintiff just came to the court and filed this case, this present case, for specific performance of contract. This is the situation. Then what do you do? So your first option is gone, which is where the law is allowing you as a party to come to the court and get your contract rectified. That option is gone because now the other parties have already filed a case. So that situation is in clause B. The plaintiff may, it's in clause C, so this clause B is building it up. So the plaintiff may, in any suit in which any right arising under the contract, I can say, if they're saying instrument, I can say contract. The plaintiff may, in any suit in which any right arising under the contract is an issue, claim in his pleading that the instrument be rectified. So if the plaintiff is only saying, he can also say in his plaint that there's a mistake. But in our case, this plaintiff is very cunning and he's trying to benefit off of this clerical mistake, this typographical error. So he didn't say it. So now defendant can say it in the same case, because the point is to not increase the number of cases. So law is not saying that, okay, defendant can go file a new case now. See this clause C. A defendant, when do you become a defendant? When there's a plaintiff. That means when a case has already been filed against you, now you are a defendant. A defendant in any such suit. What suit? Such. The kind of suit referred to in clause B. What is the kind of suit referred to in clause B? The kind of suit filed by a plaintiff to claim some right from that instrument. What is the right being claimed in our facts? Right to get it performed. Specific performance of the contract is the right of that plaintiff. So he has already filed a suit like that. So now the person who is defendant in such suit, what can he do? A defendant in any such suit, as is referred to in clause B, may do what? In addition to any other defense open to him, ask for what? Ask for rectification of the instrument. He can ask for rectification. Other defenses he can take, like what? That, oh, this plaintiff has not written the correct property's name. This plaintiff has chosen the wrong court. All those defenses he can take, but he can also take the defense of what? He can also ask the relief of what? Rectification of that instrument. Right? Now come to subsection 2. If in any suit in which a contract or other instrument is sought to be rectified, We know there's a suit now in which defendant asked for rectification. Then what? The court finds that the instrument or the contract, through fraud or mistake, does not express the real intention of the parties. After evidences and everything, court has also agreed that yes, the contract was supposed to be for 25 lakhs, but it is only for 2,50,000. Then the court may, in its discretion, direct rectification of the instrument. The court can say that okay, rectify this instrument so as to express that intention, the original intention, so far as this can be done without prejudice to the rights acquired by the third parties in good faith or for value. Forget that. So point is, court can order for rectification, defendant can ask for rectification. That is how rectification can become one of the defenses against the plaintiff's pleadings. See here, if you read subsection 3 also, a contract in writing may first be rectified. So this is what the law is saying. Law is saying that okay, you can rectify the contract, but the suit is for specific performance. So the law is saying, okay, after such rectification, then you can tell the defendant, okay, now I've rectified it, now perform it. Now perform it. And then defendant can tell the court will tell both parties then, fine, you are asking for specific performance of this contract, but it will be done only after rectification. Now I've rectified it. Now you have to perform this contract. Now defendant can tell the court that please ask this plaintiff to perform the contract. In fact, in his WS, defendant can write in the prayer that asks this plaintiff to perform the contract after its rectification. Why can he ask this? Because section 26 subsection 3 of Specific Relief Act 1963 is telling you that. It says a contract in writing may first be rectified, and then if the party claiming rectification, who is the party claiming rectification? Defendant, has so prayed that he has to say in his prayer, has so prayed in his pleading, and the court thinks fit may be specifically enforced. So defendant can say in his prayer, get this contract rectified, and then ask the plaintiff to perform this contract. Fine. Then the court will tell plaintiff, now you perform this contract. Now plaintiff will be held liable if he does not perform this contract. For breach of contract, he'll be held liable. That is how we are bringing in this argument about rectification. This is not part of CPC, but this is part of the real world. That is why I tell you, laws have to be read together. You can't put them in silos. You can't understand them like that, because that is not how life works. So we had to come to a specific relief act, and I showed you this. It's a very interesting point. This is one of the arguments that the defendants can make in such case, right? So a few examples we have taken. Another example that I flagged to you yesterday was about necessary parties. But before I take you into that, we will discuss how that pleading with respect to necessary party will be written. Today I will spend a lot of time on this. I'll actually write and show you how this part of plaint are written. Let me explain to you what are necessary parties. So when we're writing this pleading, I just don't want to write it like in thin air and just move on. No, I want you to understand why we are making this a pleading and what this pleading entails. We will discuss this concept of parties when we do parties as a topic under order 1. But for now, I'll explain to you what is necessary party